So if insurance companies in the past had made a mistake in resolving a claim, there was what was called a bad faith case against the insurance company for not paying the claim in good faith. The reality is, before March 24th, before tort reform changed, those cases were exceptionally difficult to do. In fact, we've only had a handful of bad faith cases in the 14 years we've been practicing, because you have to get a verdict that exceeds the amount of the underlying insurance and then prove that they acted in bad faith towards their insured. We actually have to refer those cases out because we're witnesses to what's called that bad faith. What the legislature did is they gave the insurance companies another bite at the apple. They said, here you go, you can make your mistake, you can deny a claim, but you know what now we have to do is give them another 120 days to rectify that mistake. So it gives them another chance to treat you right, allegedly, by the legislature. But the problem is it delays things even more. And it causes a problem with that delay many times, because a lot of times you need that money to pay for things as things go. And the other thing is the insurance companies know they don't have to make the right offer initially. Before, if they didn't make the right offer, they didn't make the right decision, they could be scrutinized down the road. Now, again, very difficult to do. Most attorneys don't even take those cases. There's just a handful of what's called bad faith attorneys throughout the state. And the reality is most of those cases go to federal court and would get dismissed or get really reduced by the federal court. So they were difficult cases. Insurance companies were usually favored by the courts to win those anyway, but it's just given them that extra bite at the apple. And mostly it could be any type of case, but a lot of times that's in car accident cases where there's minimal coverage. It'll give them a chance to say, oh, the damages to your vehicle and you are $25,000, we'll offer you 24. And the reality is what's gonna happen is people are probably gonna take the 24. This is what I used to hear from people that handled cases for municipalities and government. Years ago, the cap for government is called sovereign immunity. It means the government is immune beyond a certain level. At the time, it was $100,000. What they would tell me is the person could be catastrophically injured. Well, you know what I offer them? I offer them $85,000. I said, well, you know that's not fair. You know the guy needs millions of dollars treatment. And he said, well, we would say, you want the whole 100,000? Go get it at trial. I think operatively, that's what this law has done, is it allowed insurance companies to now do what sovereign immunity cases could do, and what the attorney said they would do is saying, you want the full amount? Go get the full amount. And the problem with that is you as the victim is you're gonna have to pay more in fees, more in costs to get to the right amount and get to that fair amount.